May it please the court. I'm not quite sure with respect to your initial instruction how I should follow that, because what we have here today is I represent the appellant cross appellee, and in a major part of the case...
You have an appeal and a cross appeal
yes,
here, and so we'll save you a little more time and adjust as needed, so that just handle your brief, not the cross appeal first.
All right, so I'll just handle, what I'll do is keep within time limits. I'll do the first 10 minutes of that, and then I'll be available 10 minutes for the other. May it please the court, I represent the husband who unfortunately today is indisposed. He wanted to be here today, but he has a fever, he is sick, and he's not here, and so I'm just alerting the court. It's not a lack of interest on his part, it's just a physical situation. These parties were married in November the 30th of 1982. And earlier than that, on November the 12th of, did I say the 30th, the 20th of 1982, on the 12th of 1982, the husband, who was then the owner of very substantial properties both here in Hillsborough and Pasco County, negotiated with representation for the execution of an antenuptial agreement. And the parties married after the execution of that antenuptial agreement. Both parties had been represented during the course of the antenuptial agreement. But then in March of 2009, the wife commenced a petition for the dissolution of her marriage to the husband. There were a number of affirmative defenses asserted, the first of which, of course, was the defense by the part of the husband that there was an antenuptial agreement. The wife thereupon responded to the assertion of the existence of an antenuptial agreement with a number, I think some, I forgot exactly how many, but a substantial number of affirmative defenses. What's significant there is that the case was bifurcated with respect to the trial of the issue of the affirmative defenses to the enforcement of the antenuptial agreement. And so on November the 28th of 2011, Judge Weiss, who was then the presiding trial judge, entered an order with respect to the enforcement of those affirmative defenses. Now, he rejected all of the affirmative defenses except one. And the one affirmative defense that he accepted as being valid and viable was the defense involving abandonment of the terms and conditions of the antenuptial agreement. And it's that order that is of such significance to us. The judge, learned judge, as a matter of fact, recognized that he had a major problem there. And here's what the antenuptial agreement said in significant parts. Very short, but it's the important part of the agreement. Each party shall retain, have, and exercise full right and authority in all respects the same as he or she would have if unmarried to use, enjoy, manage, convey, and so forth all of his or her present properties. Now, that clause is the clause that Judge Weiss recognized was a clause which, with respect to each of the acts, which he said, some 11 acts, constituted indications of abandonment, no one of which was significant. In other words, Judge Weiss entered into, I might add very quickly as an aside, the legislature has disposed of the problem that's now before you under the new act. Under the new act, there's a specific provision with respect to how one terminates the obligations established by an antenuptial agreement. So we're really dealing with a pre-legislative determination of how this was to be done. Judge Weiss, therefore, was not significant because the effective date of the statute was after, subsequent to the party's execution of this agreement. So what Judge Weiss did was he identified a number of acts which he said any one of which was inconsistent, any one of which, standing alone, was consistent with the enforcement of the antenuptial agreement. I almost want to quit using the phrase antenuptial agreement and use instead the word contract, because an antenuptial agreement is a type of contract. And what Judge Weiss has said in this particular agreement is that the parties can abandon by conduct the enforcement of the antenuptial agreement and therefore not be bound by its terms. Now, I'd like to also point out to you what he said. He said the court ultimately rejects this argument, and he's referring to the argument that every single individual act was in and of itself consistent with the paragraph I have just read to you, and said, however, this particular cumulative course of conduct by the parties throughout their long-term marriage is wholly consistent with the provision, inconsistent with the provisions and purposes of the parties' antenuptial agreement. Now, what we have, if I may express it in mathematical terms, is that 0 plus 0 plus 0 no longer equals 0, but is equal to enforcement of the unenforcement of the antenuptial agreement. In other words, we have 11 acts any one of which examined in isolation would be consistent with the terms and conditions of the antenuptial agreement and would not be evidence of the abandonment. However, Judge Weiss has developed a new theory of law that when one examines all of these innocent acts, all of these acts which are consistent with the enforcement of the agreement, the cumulative examination in his judgment amounted to an abandonment. Well, if you look at the acts themselves, you will see why that cannot possibly be so and why it would be against policy of the estate. By the way, not one single case has been cited to support the position advanced by Judge Weiss. Not one. Nor can any such case be advanced, because there is no case that supports this new theory that when you take a series of acts, any one of which is consistent with the agreement, examine them in toto, and then conclude that there's been an abandonment, that's a new theory of law. And you have de novo authority to examine whether or not he was correct in that regard. And fortunately, he laid it out for us in his thing. So he has ignored totally the impact of what I would call the retained powers clause, which is the clause that I first read to you. That is, what powers does a person have in connection with the execution of an antenuptial agreement?
Which paragraph is that?
That's paragraph, that will appear as paragraph 3, as I read, paragraph 1, Your Honor, of the antenuptial agreement itself. It's quoted in paragraph 8 of the judge's order. Paragraph 1 is going to be on page 3, as I recall, Your Honor, and it will say, I'm sorry, page 2 of the antenuptial agreement. I hope that one certainly shows up in this.
I haven't read through all of them to try to compare this exactly, but a lot of the things are situations where the party retained and exercised the right to dispose of property, but they put it into joint accounts and did things with joint accounts thereafter. Doesn't that make a difference?
No, and let me explain why it doesn't make a difference. First thing to remember here is that all of the property basically was owned, some small amount of property was owned by the wife, but basically all of the property was owned by the husband. And the parties lived off of the sale of that property. In other words, the sale proceeds of the property from time to time would be deposited in joint accounts. But the money that would come in, some of it, at least to live on, would be the money that would be deposited in the joint account. And certainly, as you'll hear later, there were substantial sums that were never put in those joint accounts. So to put money into a joint account standing alone is exactly what he could do. You could call each such deposit as a gift by the husband to the wife. And that gift is certainly something that's permitted by the retained powers clause I was referring to. Now, it's not that, even the judge below recognized that that was consistent. I thought perhaps you might ask what might be a harder question, which would have to be, and I'm not suggesting you didn't think of it, but I'm suggesting that the hardest question he could have asked was one that he himself found was consistent with the retained powers clause, and that is the fact that the husband executed a power of attorney in favor of the wife at one point. Now, the power of attorney, you might say, well, did he have the power to do that? Well, you have to look at the circumstances under which he gave her the power of attorney. It was part of an overall estate planning. It's a time when he had melanoma. It was a time when he was sick. He wasn't certain about his future. And there was nothing wrong with him doing that. As a matter of fact, there was nothing wrong with him having transferred every single piece of property he had to her, which would still not constitute an abandonment of the agreement. It would constitute the exercise of a power he had under the paragraph I quoted. So the precise legal question that's been presented for you is, can a series of acts, each of which is innocent in and of itself, when examined cumulative, amount to an abandonment of an agreement? That totally ignores the case law of this court in McMullen. It totally ignores the case law where everything must be an unequivocal expression, and we cited the cases to support that proposition. The other 2 points I'd like to touch upon ever so briefly before we get into what's ultimately going to be, I think, the significant thing here, have to do with a mathematical error that was made by the trial judge. The mathematical error that was made by the trial judge had to do with the determination of how much of the appreciation with respect to the marital home was going to be allocated to the wife. What the trial judge did was she took the expert testimony of a Mr. Menard, who was the expert called on behalf of the wife, who had valued the marital home. Mr. Menard's testimony was, though, that the value of the marital home at the time of the marriage, the marital property, was 1/2 because the husband only owned 1/2. But when the trial judge went ahead and granted the wife or classified the appreciation as marital, she did not take account of the fact that subsequent to the marriage, the husband, through exchange of other non-marital property, became the owner of the full fee in that particular property. And under those circumstances, there's an error, that the husband was not given credit for. So what we're saying is, if you take a look at those numbers that we've expressed there, you'll see very clearly why the trial judge made such a simple mathematical error. The last point that we wanted to raise in our direct appeal had to do with the $220,000 sum that the wife took almost immediately following the petition, or just before the petition filed for dissolution of marriage. She took a $220,000 CD and she went ahead and cashed it in. That $220,000 CD was in the husband's name alone. It was his non-marital property. Now, what made it unusual is that the wife treated that particular property as though it were a marital asset which had been expended during the course of the proceeding. That was error. What she should have done was gone ahead and charged the wife's marital share with the $220,000, and then she should also have imputed income to her at the rate of 3% during the period of time that she had that. This wasn't done. This has been laid out as well.
During the term of the divorce proceedings, was there support provided every month for the wife? Is this in addition to what was determined to be adequate temporary alimony?
I know there was support in addition to the temporary alimony. I don't think so, Your Honor. There was support provided to her, but the question you're asking.
Was there a temporary alimony award?
There was indeed, Your Honor, and he honored that temporary alimony award, temporary support award. And that's in point. That closes the argument I'm making with respect to that point. She got the temporary support. She was not using the non-marital funds, and indeed the trial judge doesn't make that finding. The trial judge makes the argument that because the asset no longer existed except with respect to a $70,000 Cadillac she bought, that asset was not something that she could deal with. That argument, though, is, in our judgment, premised on an erroneous assumption. And the assumption was that that was a marital asset, and there was no establishing that it was a marital asset. Had that been a marital asset, had she used it for purposes related to support, then the disposition she made was correct. She did find that there was no evidence of dissipation, but we weren't dealing with dissipation in this case. Dissipation is involved when you have a marital asset that's been expended during the course of the proceeding.
If we were to reverse on the antenuptial agreement, it has a waiver of alimony, and what assets then would be, what would happen on remand?
On a remand, I hearken to one of your opinions, and where you refer to the fact that there has to be an explicit waiver. I would suggest to the court that at this point, that what would really be involved in a remand would be the loss of her right to claim an attorney's fee. She would not have to pay back any temporary alimony support under the Fernandez case. What would then be involved would be what would she be entitled to under the terms of the actual antenuptial agreement. The absence of the explicit waiver would not require this court to revisit the issue with respect to appreciation, because there's no explicit waiver of appreciation in there. So I don't think there would be that many changes, except for the fact that she would not have the right to alimony, and she would not have the right to the attorney's fees that she may be claiming. The other point, though, and I point this out to the court.
But there would be significant assets for equitable distribution there?
But still, she's got nearly $4 million as it stands right now, and there still would be significant assets for equitable distribution, but depending upon the resolution of the second part of the argument, it may be that you're not even going to have to deal with that point.
Okay.
Thank you, Your Honor.
Thank you. Mr. Elliott?
Thank you, Your Honor. May it please the Court, Tom Elliott here on behalf of Sheila Geraci. I'd like to reserve 5 minutes for rebuttal on the cross appeal.
Sure.
Judge Weiss wrote a thoughtful order, but not an equivocal order. You heard something about, well, he said it wasn't inconsistent, or it was sufficient, wasn't sufficient. That's not what he said. The order says that he recognized the plaintiff's argument that any one of these acts could be deemed to fall within the gift paragraph. But he didn't say they did. He rejected that expressly. Saying something could be deemed to be something is what the trier of fact does. It's just like saying these facts could give rise to different inferences. The judge heard 14 days of testimony, and then he deemed there to be an abandonment, which is a factual determination. As we have pointed out, that's the standard of review. What he found here were, I count them as 13 instances, many of which are multiple. For example, I mean, Sheila's home proceeds went into a joint account that was then used to pay expenses, including expenses on Peter's property. Same thing with her $200,000 inheritance into an account used by Peter, including to pay for expenses on his property. Anyway, there's plenty of factual support. It's a factual question. The judge heard 14 days. The fact that he wrote he said that it was the inescapable conclusion from the clear and unambiguous course of conduct. There was, as we point out in the briefs, there was no requirement that one party get up and say, oh, I have abandoned it. If that were the case, you wouldn't be litigating the issue. None of those cases do you have somebody saying they abandoned it. Now, in this case, you did have direct testimony from Sheila that she was told that the agreement would no longer be adhered to if it was a long-term marriage by Peter.
Is there any Florida case law recognizing an abandonment theory for this kind of situation?
Well, we've cited a number of abandonment cases, yes, and they're all different situations. Sometimes it's an act if somebody does it's inconsistent. Most of the cases it's one act. One act. We've got 13 categories of acts here. So plenty of evidence for the judge to make this factual determination that's entirely consistent with Florida law. Unless there are any questions on that, I'll turn briefly to the so-called mathematical error in the valuation of the marital home. I guess that's what it's being called this morning, but that's not really what the brief describes it as. The brief, there are two things. They say, well, the trial judge, second trial judge for that part, generally accepted the husband's expert testimony on valuations, but on this one she went with the wife's, and she shouldn't be allowed to do that. The prior fact can pick the expert testimony they want on a particular issue, so that's nothing. The other point is section 61.075 is argued, but as we point out, that was not argued below, so it was not preserved, it is waived. So if there is any validity, that point is gone.
So what we'll call the mathematical error portion of this argument, the 50% part was not raised below on rehearing or otherwise?
Correct. There, if you look, and I appreciate you struggling with the record, but
the husband's colder on this case than normal because it's been very hard to go through the record.
I hear you. I hear you. The reply brief, the husband's reply brief at page 14 says, oh, the husband raised the 50% issue and cites the 37 pages, the full 37 pages of their memo, their rehearing motion. Okay. There's only a couple of pages, and they are pages 12965 to 66 of the record, where this issue is discussed in the husband's thing. We point out in our answer brief at page 27, it's not there. There's no reference to this statute number there. Okay, so that's just not preserved, not an issue we have to worry about. On the $220,000 CD, you heard today, this is something that happens before the petition. What you didn't hear is that the husband testified at the trial that it was the party's practice to transfer money from the CD when we needed money. That we transferring money was a regular practice. So that was nothing unusual. Now, $200,000, during the course of the dissolution proceedings, the husband spent $6 million. $1.2 million of that went to the wife. If they want to go back to day one and do it even, we'll give them the $200 and they give us $1.6 million and we'll be even. But unless they're ready to do that, to complain about $200,000 she took to live on before alimony got started, temporary support got started.
When did temporary alimony get started?
I'd have to check on that, Your Honor, but it wasn't right away. And you heard today, oh, he honored this.
The temporary support was sizable in this case, but I forget how much it was.
Right. Well, it wasn't half of $6 million. Yeah. It amounted to $1.2 million over the course of the dissolution.
But, I mean, we're still dealing with a situation where she, apparently without dispute, took non-marital funds. These are his funds, not marital funds, right?
They were in the CD in his name. That he testified when both of us needed money, we took it from the CD. In other words, she had done this before. This wasn't
She had power of attorney to do this kind of thing.
I'm not sure if the power of attorney was still in effect at that point and encompassed that. I haven't looked back at the power of attorney, but she had. You're correct. She had. Pardon?
How did she manage to do it?
Oh, because it was a regular practice with this bank. I mean, the bank knew she needed money, she'd come get it. He needed money, he'd come get it. It was a regular practice. I mean, he testified to that, and then he moved the transfer during the whole dissolution. Never complains about it for 4 years. That's an agreement. That's ratification. So, as we point out. Okay, on the cross appeal. And I would agree that the cross appeal issues regardless of how the court were to look at the prenuptial agreement, cross-appeal issues are in play because cross-appeal issues deal with the enhancement to these properties. And there are two aspects to that. There's a property called Calusa Trace. Excuse me, that was owned by Peter at the time of the marriage, was worth, the testimony from his own appraiser is worth $1.8 billion at the time of the marriage. It sells 3 years later with entitlements, enhancements, and so forth for $11 million. The money from the sale goes to pay for other properties that are held in Peter's name or Peter and his brother's name. Okay, and those are all listed in an exhibit. There were several exhibits, but exhibits prepared, including by Peter's expert. I'll come back to that in a minute. There was evidence and stipulations on the record that marital labor was used to enhance this Calusa Trace piece of property that then sold. Marital labor and funds. We've recited the evidence in our brief. If you look in our reply brief at pages 4 to 5, we detail the marital efforts on rezoning. And the husband spends a lot of pages in the answer brief on the cross-appeal saying, oh, well, you know, we had done all this before, we'd done that before, and they put somebody on who says 95% of the effort on this piece of property on Calusa Trace was done before the marriage. Well, that kind of proves our case. 95% was done, 5%, even in their terms, was done after the marriage. Marital labor after the marriage.
Now, the piece of property sold for a much higher price after it was rezoned, right?
I'm sorry, what now? The higher price, yes, yes.
The rezoning?
It was not rezoned until 1983 after the marriage. And then it was sold in 85. So we have marital enhancement. Okay, now they could have come in and said, and then those funds, and they're correct, that piece of property is then gone. It's not there in 2009, but all the pieces of property that it bought, that it paid for, paid off, are there in 2009. So those are in play, and marital, you just trace the money. It's easy. Marital enhanced money went to pay off those. It's in those properties. Sheila had an interest in that. And the husband could have tried to do an analysis and had his appraiser proportionate and say, here's what, you know, okay, it was 95 and 5 or whatever. They didn't do that. And the Abnauer case and Geraci, if I'm saying that right, I think Judge Crenshaw, I see you were on that panel. I don't know if you can help me with that pronunciation. It looks like Geraci to me. Both those cases hold that when the owner of the property doesn't come in and put on evidence to apportion it, it's 50-50. So the enhancement should be 50-50 on all these properties. And we have the 1982 values. That is in, and again, I appreciate you don't have this record. We can get to this. Husband had several exhibits. Husband's exhibit 24, which is at volume 88, page 16505 of the record, has a list, and it has the 1982 base, and then it has the 2009 value. So it's a simple matter to take that difference, cut it in half, and that's Sheila's share. It's an easy mathematical calculation to do.
And if all this was done, then we would have to go back and reopen alimony and decisions for attorney's fees and things like that.
There's been no decision on attorney's fees. That's not been done. Potentially, yes. If she got a greater equitable distribution, that would impact alimony. Agreed. Yeah. They didn't put that evidence on. And of course, when they're trying the case, they didn't know how the trial judge would rule. And they gambled they would lead the trial court in error, which they did. But then when you don't put on that evidence, you have no fallback, and it's 50-50 under this court's decisions in Abnauer and Geraci. If the court agrees with us on that analysis, which I think follows very logically from what we've laid out there and from the evidence, and I talked about there being the evidence showing that there was marital labor put into the Calusa Trace property after the marriage and before it was rezoned. There's also testimony or stipulations repeatedly on the record, and we detail those at pages 5 to 8 of our reply brief on cross appeal. Now, if you agree with us on that, then I think that takes care of it. The passive appreciation is going to be captured within the 50-50 split. There won't be any need to do a separate passive appreciation analysis. But if the court did not agree with us on the Calusa tracing, if you will, the Abnauer 50-50 approach, then we do have a passive appreciation issue, because when you look at those numbers, clearly these properties went way up. Some of it was for marital effort and labor, some of it was market forces, what was called passive appreciation by the experts and by the trial judge. The Ka case that we have cited, the trial judge applied that to the passive appreciation of the marital home, and Sheila got half of that. The husband argued below that Ka only applies to marital homes, and the trial judge agreed. That was error. The cases, I mean, Ka doesn't say it's limited to homes. It dealt with the marital home, but it cites the statute, which is much broader in marital assets. There have been the Burton and the Jordan cases. Since then, we've cited which one deals with one spouse's property in North Carolina, another one with an office building. It is clear that if you have passive appreciation where there's been marital effort involved, you have marital effort from either side. And here you had it from both, eventually, because Sheila did work in the business at one point. But you have marital effort, then the passive appreciation needs to be shared. And again, husband put on no evidence. The husband's expert's approach was to say, well, I'm taking all the passive appreciation and just taking that out. She doesn't get any of that. And that's clear. Again, appreciate the record. Issue 136, volume 136, at pages 1462 to 66. Is the husband's expert's testimony where he eliminated all passive appreciation. So, if we don't do collusive trace, we do need to do passive appreciation calculation. Again, under Abandonment or Geraci, because they put on no evidence on it, they just took it out completely, that should be 50-50, we would suggest. So if the court has any questions on either part of it, I'm happy to try to answer them. Otherwise, I will wait for rebuttal.
Manny?
Other than the fact that this wasn't argued below, let me show you where the real flaw in the argument lies. The assumption by counsel, Mr. Elegant, is that there was marital labor on the collusive trace property, and because there was marital labor on the collusive trace property, 95% may have been non-marital, but 5% was marital labor. That is the period of time in the 4 months following the marriage of the parties and the time that the property was rezoned, that constitutes enhancement. And indeed, the statute specifically provides, it's been renumbered, it's the old 61075, I think it's now 61076 or whatever. But the statute specifically provides, by definition, and I'll just read that to you, marital assets include the enhancement in value. It doesn't say diminution. It says the enhancement in value of non-marital assets resulting from the efforts of either party. What's missing in the analysis that's been advanced is any proof at all that this entitlement procedure, this rezoning procedure, enhanced the value of the property. Your Honor, you made the assumption when you asked the question, well, didn't they sell it for a lot of money afterwards? You're asking the question that the trial judge could well have asked attorneys during the course of a proceeding. And the question is, did the entitlements enhance the value of the property? It would hope, obviously the parties would hope it would enhance the value of the property. But now back to the record. This record is void of any attempt whatsoever to show that these entitlements enhance the value of the property. And indeed, there was even testimony at one point in the proceeding by one of the experts to the effect that getting entitlements actually diminished the value of one parcel of property out there, not one known by my client, but it was one used in illustrative purposes. So step one, before you are entitled to anything by way of marital value, is to show that the marital labor enhanced the value of the property. I'm reminded of that famous tree case where the wife contended that the growth of the trees on the property during the course of the period was an enhancement to which she was entitled a part of. Well, let me change the hypothetical just a bit. Let's suppose that the day after the marriage, the wife, in the zeal to make the trees grow even faster, put 2,4-D on the entire tree farm instead of fertilizer and destroyed the growth of the trees. Her marital labor would not have enhanced the value of the property at that point. It would have diminished the value of the property at that point. So you have to show enhancement, not diminution. Marital labor alone will not suffice. And this record absolutely is void of any testimony whatsoever that the efforts of the husband to get these entitlements, that 5% effort, enhanced the value of the property. By the way, this property is the old Galleria property, in case you aren't aware of that, but it's the old Galleria property. So let's talk about then what's required with respect to that, and say quickly, they didn't prove it with respect to collusive trace. They didn't argue it below with respect to collusive trace. And frankly, I attribute it to the high capability of counsel that the argument is being made for the first time on appeal. With respect to a minor point, that is that we failed to raise the issue with respect to the error of the trial judge. I would ask that you just take a quick look when you get the chance at paragraph 3A2 of our motion for rehearing. Paragraph 3A2 of the motion for rehearing specifically raises the issue with respect to the 50%. Let me come to CAW for just a minute. CAW is a more interesting case. I don't think it's as difficult as some people seem to make it out. CAW has a, yes, I hear you, Judge. And we're not critical of it's ours, we accept it, there it is. But if you look at page 872 of CAW, you see a title there, Determining an Award of Passive Appreciation. In other words, I will look at paragraph 6 through 10 under the caption, Determining an Award of Passive Appreciation, and I will suggest to you that what they're trying to do there, forgetting the moment, the temporal problems with respect to the payment, is they're trying to say, if you're going to have an award of passive appreciation given to a non-owner spouse, this is how you calculate it. First, the court determines the overall current fair market value, and that was done below, and I'm now talking about with respect to all the parcels other than collusive trace as to which this was applicable, that is the 6 parcels as to which we stipulated. Second, the court must determine whether there's been a passive appreciation. We took that burden on and offered testimony through our expert witness as to what the passive appreciation was. Third, the court must determine whether the passive appreciation is a marital asset under section 61075. And the court helps you. They're going to tell you what 61075 says. This step must include findings of fact by the trial court that marital funds were used to pay the mortgage and that the non-owner spouse made contributions to the property. I don't think we need to worry about marital funds, that's not proven, but they must find the fact that the wife in this case made contributions to the property. And indeed, with respect to the homestead, that's exactly what the trial judge did. There was evidence that the wife had made contributions to the homestead. That's why she got all the passive appreciation. Next, or at least one half of it, I should. Next, the trial court must determine to what extent the contributions of the non-owner spouse affected the appreciation of the property. Was this done with respect to any property other than the homestead property? The answer is no. You will find no attempt on their part to do that. Their expert witness testified initially it was impossible for him to determine the difference between marital and non-marital appreciation. Our expert witness did testify as to the difference, and we quantified what part of the passive appreciation was going to be associated with marital efforts, and what part, or I should say, what part of the appreciation was marital, and what part of the appreciation was non-marital. At that point, it could have been that the wife would have offered testimony as to show what part her efforts made to that, but she didn't. She didn't do it. She didn't have an expert that was capable of doing it, although later the expert came in, but the trial judge below said, wait a minute, you can't come in here and testify in the first part of your case that you can't quantify marital appreciation and passive appreciation, and then come back later and say, I've changed my mind, I guess I can after all. So I would have to tell you that this part of the case is absolutely correct by the trial judge below. Let me point out something else. The trial judge went to efforts to explain, in fact, in her opinion, why, with respect to the collusive trace property, there was not going to be any determination that any part of that property was marital. The wife's counsel made that argument below and tried to say initially that the proceeds from collusive trace had been placed into a joint account, and the money came from a joint account. That evidence was rejected by the trial court, and this is what she said. The funds used by Nick, that's the husband's brother, and the husband to pay their mother and Aunt Rosalie for the mortgages that were outstanding were non-marital, either because they came directly from the proceeds of the sale of the non-marital collusive trace property, or because they came from distributions from Geraci and Company, a non-marital asset owned by the husband. So we submit to you that the wife absolutely failed to establish the value of her contribution. She absolutely failed to establish that she made any marital contribution to Calusa Trace property. She did not establish the value of any that was associated, and she didn't establish that the contributions she made contributed to the enhancement of the value. Now, that's where we stand. I might point out also, this was the 80s when you don't know what was happening with respect to the value of property as a result of so-called entitlements. That's just a practical matter with respect to this particular piece of property. The only other point I'd like to make, Your Honor, is with respect to the cumulative course. One point. It was the judge himself who said it was a cumulative course of conduct. He recognized, I don't think it was a judicial musing, as it were, this trial judge recognized quite correctly that every one of these acts could be argued to be consistent with the retained powers clause. But he goes on to say, but it's the cumulative course of these acts, these innocent acts, these acts within the ambit of the retained powers clause, which in my judgment means there was abandonment. And we think that's error, and there's no case to support that type of proposition. Thank you very much.
Before you sit down, I'm pretty sure I know what your position would be if you prevailed on your first point on appeal, but they have a pending motion for attorney's fees. And can you address briefly how you think we should respond to that motion?
Yes, sir. She's got over $4 million right now. Over $4 million in assets as a result of this particular equitable distribution, the one that's in place. And even if we had prevailed on the first part of it, to answer your question directly, we're not talking that significant a part. She'll still be a multimillionaire, which is pretty good given the course of history in this marriage. And then the money came to them from the husband. Then it came to her from the husband, from his inherited funds, because this husband has not worked throughout the marriage. They've lived on his inherited funds.
Yeah. Okay.
Thank you, Judge.
Thank you. And Mr. Ellicott, could you respond to that same question since it's hot on my lips?
Oh, on the fees?
Mm-hmm.
Yeah, I think I think regardless of any rulings, it needs to go back for a fee determination. It would have the I'm trying to remember the name of that case that this court has issued. The Rados case, yeah, would go back. I think we even cited that in our motion, go back for an analysis. Because, and obviously, certainly if you agree with us on the 50-50 split on the enhanced value, that's going to put her in a different situation. And if not, though, I mean, this was an expensive case to litigate. There are substantial fees outstanding to experts and so forth. So it would significantly diminish the wife's recovery if she had to pay all of her own fees. Okay, to try to, first off, as far as the suggestion that the Calusa Trace argument was not made below, it's made in multiple places, but the first one I could find is in the wife's motion for rehearing, which volume 110 of the record, 20808, and it starts off by saying, Calusa Trace marital enhancement, final judgment, does not account for the significant portion of the Calusa Trace proceeds that resulted from marital funds or labor. And it goes on from there to argue, hey, you need to go back and do this. That was denied. So it was raised below. As far as the suggestion that there's no evidence that the Calusa Trace, the enhancement of Calusa Trace with the entitlements to the rezoning, then added value to it so that it went from 1.8 million to 11 million in the 2 years after it was rezoned. There was direct testimony on that when the husband's brother is testifying at the trial, and he was co-owner in all these properties, or many of the properties, asked if the rezoning was a necessary entitlement for the Calusa property to be resold, Calusa Trace property resold, and he testified affirmatively. And that page, that is volume 127, which starts the second round of trial testimony. Once we get into that, 127, page 133. So getting to your point of the trial testimony starts again, it certainly does when they get to the valuation trial.
What about the argument that there's no proof of enhancement by marital labor, though?
I'm sorry, what now?
Mr. Manley's argument that the record doesn't actually contain, I suppose, expert testimony on enhancement by marital labor here. It may be intuitive, but is there sufficient evidence on that issue?
Okay, I misunderstood. I thought he was saying there was no, okay. Well, I don't think you need expert testimony on it.
Right.
For one thing, you have the owner of the property, the co-owner, testifying, we had to get this redone to sell it. And it was done. You had, there's other testimony there. Whether the appraisers actually said you need these entitlements to sell the properties for every property, I'm not sure that there is that direct testimony. I think there may be. I mean, we'd have to go back and look at that. But as far as was there marital labor put in that enhanced the property, that was the labor to get the rezoning. That was, whether it's 95 and 5 or some different proportion, there was marital labor spent after the marriage, and there's testimony that from the lawyer who worked on that there were a number of meetings, that Peter attended those meetings, and that culminated in the rezoning approval for the property. There's then direct testimony from the brother that that was necessary to be able to sell the property. So that's an enhancement. I don't know how much clearer it could be. We can look back and see if the appraisers also testified that, but it's also common sense too. I mean, there was testimony that money was spent on properties that didn't get entitlements.
Did he do this himself? Did he hire a lawyer? How was the rezoning done? Do we know from the record?
Oh yeah, there were lawyers involved, yes, but there were also meetings and.
Did they use marital funds to pay for those lawyers?
Yes, I would say there's evidence that they did, because we have the evidence that Sheila's, I don't know if paid directly for those lawyers, but we have evidence that Sheila's home proceeds and her inheritance both went into the joint account that then Peter used for, among other things, to pay for his properties. So these other properties, as you go forward, you have that pay. Now, the suggestion that the judge's finding that the collusive trace money went into a joint account of the two brothers, that doesn't remove, if the collusive trace proceeds have a marital element, which they do, because you have marital labor involved in getting those. And that's, again, we point out in pages 5 days of the brief, repeated times when they stipulate, when we started trying to ask questions about the marital labor on properties, and there are repeated stipulations that, no, we agree marital labor was spent on these properties. They try to say, oh, we didn't mean collusive trace, but we traced you through the testimony. I'll be glad to provide you those in an appendix, where it's clear that the collusive trace is among the properties they're talking about. Anyway, that money, once you get collusive trace proceeds, which has a marital component, they put it into a joint account of the brothers. She was not on that account. They say, oh, and the judge says, well, it went into an account that she didn't have an interest in. You can't take marital property, marital proceeds, and put it into an account that's just yours and deprive it of the marital aspect of that. The Capote case that you authored last year, Judge LaRose, stands for that proposition. It goes back and cites the Frankel case from earlier. When you put money, it works both ways. You put money into a joint account, it becomes joint between the husband and wife. You can't take joint money, marital proceeds, put it into an account of your own and say, oh, now I've cleansed it of the marital aspect. It doesn't work that way. I mean, you can imagine the abuses that would give rise to. Unless there are any questions,
Okay.
we would ask that you affirm on the prenuptial, reverse on the cross appeal. Thank you.
Thank you. Next case on the docket is Chmielewski versus City of St. Petersburg Beach.